How's it going, everybody? In this video, we're going to be talking about the Jones v. Becerra case. This is a case which deals with challenging California's age-based ban on specific individuals being able to purchase firearms. So let's get into this. But real quick before we jump into this video, if you think that if someone's old enough to go to war, they should be old enough to purchase a firearm, go ahead and hit that like button and subscribe. I also want to give a shout out to a couple of our sponsors, the first being Becerra and the other being Got Your Six. These two companies do a lot to support this channel, support what I'm doing here, and without them, this would not be possible. So I highly recommend that you guys click the links down in the description section as well as in the comment section. Go show them support. Becerra has California-specific parts and features that you can purchase from them, as well as Got Your Six has a firearms owner-specific app. So go ahead and take a look at them, and like I said, I put links to them down in the details section. So Jones v. Becerra, this is one of those cases that's kind of flown under the radar for whatever reason, but this is a very significant case. It's a very significant case specifically for individuals in California and for a specific subset of individuals in the state of California who actually want to purchase firearms. Jones v. Bacer deals entirely with a challenge to California's penal codes, which restrict individuals, and specific individuals 18 to 20 years old, being able to purchase handguns as well as other types of firearms as well, pretty much precluding them from being able to purchase a vast majority of firearms that a lot of individuals would want to purchase for self-defense. And why this is such a significant case as well, beyond just that challenge to those subset of laws which affect individuals 18 to 20 years old, this case is very significant also because it's up in the Ninth Circuit right now as well. As of December 4th, individuals at Cooper and Kirk actually filed the opening briefs for this case. So this case is proceeding and is going forward in the Ninth Circuit. And many of you are familiar, there's a lot of cases right now that we are keeping our eyes on, especially up in the Ninth Circuit, like Duncan v. Becerra, Rody v. Becerra, Rupp v. Becerra. There's even the Hawaii case that is a full en banc panel. I mean, there are a ton of cases right now in the Ninth Circuit that we've been keeping our eyes on and that we are really anticipating and hoping for favorable decisions as well. And this is just another case that we can add onto the list of cases that we should be keeping our eyes on. And the appeal up to the Ninth Circuit is an appeal to the district court's denial of a preliminary injunction in the lower court. So similar to what we've seen in other cases like Rody and Duncan and stuff like that, there's being an appeal up to the Ninth Circuit because the district court has denied a preliminary injunction, and this is kind of revolving all around that preliminary injunction stuff that you guys see pop up a lot in these Second Amendment cases and these California Second Amendment cases. And so if you guys want to take a look at the opening brief and also the news flash that deals with this case, Jones v. Becerra, I'll put a link in the details section. You can find it on Firearms Policy Coalition's news flash and the press release stuff, as well as there's a case folder for Jones v. Becerra. But what I want to read for you guys is the opening brief, and it's the first paragraph of the introduction. And I think this is a good summary of what we're dealing with here in Jones v. Becerra. And so the introduction says, the Second Amendment right to possess and carry weapons in case of confrontation presumptively belongs to all Americans, not an unspecified subset. Upon reaching the age of 18, the plaintiffs in this case were deemed adults for almost all purposes, and certainly for the purpose of exercising constitutional rights. They are allowed by law to vote, enter into contracts, and get married. Indeed, at age 18, they became eligible to serve or be conscripted into the military to fight and die by arms for the country. Yet the California statute challenged in this case, California Penal Code Section 27510, categorically bars them from purchasing or acquiring all semi-automatic centerfire rifles based solely on their age. Taken in combination with existing state and federal laws barring 18 to 20-year-olds from acquiring handguns, the result of the challenge provision is that the vast majority of firearms, including the firearms most useful for self-defense, are now off limits to law-abiding Californians in this age bracket. That age-based firearm ban must be enjoined, for the Second Amendment takes such a draconian infringement of the right to keep and bear arms off the table, and that is a citation to Heller. So that's what this case is all about. It is about California's Penal Code, Section 27510, which targets a subset of individuals based on their age, 18 to 20 years old, and essentially bars them from being able to purchase a subset or specific firearms, primarily, and as stated in here, the vast majority of firearms that an individual would actually want to purchase for self-defense, like handguns and other types of rifles. And they do this all while there are other laws that essentially make these individuals 18 to 20 years old legal adults in California and legal adults in the federal government's eyes as well. These subset of individuals, like mentioned in this introduction, are able to go to war. They're able to enter into contracts. They're able to enter into marriages as well. They're able to do a ton of things, but for some reason, they are precluded from exercising their Second Amendment rights in the state of California through this penal code and also through the implementation of other federal laws as well. And so that's what this case, Jones v. Becerra, is all about. It is a challenge to those California laws which will preclude individuals 18 to 20 years old being able to purchase firearms that they would want to purchase for self-defense. And this case does more than just challenging that actual aspect of California law as well. Like we've seen recently in the Ninth Circuit, in decisions like Duncan v. Becerra, once the Ninth Circuit makes a decision on a case and analyzes it, applies whatever level of scrutiny that they want to apply to it or whatever standard that they want to apply to it in analyzing these cases, that sets precedent for other cases as well. So again, this is just another case that could establish building blocks for future Second Amendment challenges within the state of California as well as within the Ninth Circuit as well. And so this is an interesting case because it is a clear categorical ban on a subset of individuals and precluding those individuals from being able to purchase specific types of firearms within the state. Again, there is absolutely no logic to this California restriction. Individuals who are 18-year-olds to 20 years old are deemed smart enough, adult enough to vote, enter into contracts, enter into marriages, go to war and die for our country, but for some reason they are not considered adult enough, mature enough to actually exercise their Second Amendment rights and purchase specific types of firearms because for whatever reason, the state of California just doesn't think that they're mature enough. And I'm sure a lot of you just think that's completely nonsensical, as I do as well. I think if the state and the federal government is considering you adult enough to go to war and to fight and die for our nation, then you should be able to exercise your Second Amendment rights, of course. And so this is something that we will definitely be keeping our eyes on, and I will keep you guys updated whenever we get additional information on this. But like I said, this is one of those strange cases that's kind of flown under the radar, which really shouldn't be because this is very significant. It has a lot to do with core fundamental Second Amendment rights, not just in the state of California, but just core fundamental Second Amendment rights at large. Like I mentioned, if you want to look at additional information on this case, Jones v. Becerra, or if you want to read the opening brief for yourself, I'll put a link down the details section to Firearms Policy Coalition's website. FPC is one of the named plaintiffs in this case. So again, like I've mentioned in some prior videos, FPC is doing a lot to actually advocate and fight for Second Amendment rights, not just in the entire US, but specifically as well in the state of California. And there's a lot more other things in the work as well. So definitely keep your eyes on this channel because I'll be updating you guys on that as well. So if you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, subscribe, and make sure you hit that notification bell because that helps the channel analytics, helps us spread the word about the Second Amendment, also helps spread the word about things like this that are going on in the state of California. So as always, thanks you guys for watching. Don't forget to like, subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.